Hello, my name is Catherine Dixon and I'm the Director General of CIArb, and I'm delighted to welcome you to this fireside chat between Ryan Robertson and Claudia Solomon, the 2021 Presidents of CIArb and the ICC. CIArb and the ICC have many things in common, and as the CIArb's Director General, I'm excited to participate in today's discussion. CIArb has over 17,000 members in 149 countries, practicing all areas of ADR. We work with governments and business around the world to help create an environment that is more conducive to arbitration and ADR. And our first-class training courses help both practitioners and non-practitioners alike improve their understanding of best practice in dispute resolution. Under the terms of our Royal Charter, CIArb has a public interest mandate, and our three strategic aims are to globally promote the constructive resolution of disputes, be a global inclusive thought leader, and develop and support an inclusive global community of diverse dispute resolvers. In delivering our strategy, we are always open to working in partnership with other organisations with shared interests, and the ICC is a prime example of such an organisation. We are both global bodies with a shared commitment to promoting the use of arbitration and ADR as alternatives to court. CIArb and the ICC provide high-quality rules and guidelines in which parties can have full confidence, and we're both well-established leaders in arbitration and ADR, and we're committed to delivering tangible improvements in equality, diversity and inclusion within our organisations and in the wider profession. I'm excited to discuss these issues with our presidents today. In a second, I'll hand over to Danga Kamau, the Vice President of the ICC International Court of Arbitration and President of the ICC Africa Commission, to introduce Anne, CIArb's President. But before I do, just a bit of housekeeping. Danga and I will be putting questions to Anne and Claudia. However, we hope to have time at the end for the audience to ask some questions. So please do put questions in the Q&A box and we'll get through as many as we possibly can. We're aiming to finish the chat by around 3:30 p.m. London time. Danga, over to you.
Thank you very much, Catherine. I'm really delighted also to be here in such distinguished company. Fireside chats, a term which we use quite commonly these days, were first used to describe a series of radio addresses by President Franklin Roosevelt in the United States. They started in 1933, soon after his first inauguration, and continued right into 1944. Through a period when there were multiple crises, including the Great Depression and the Second World War. Through these addresses, President Roosevelt was able to comfort and reassure Americans at a time when they were gripped by anxiety, despair, and great uncertainty. Now, at a time today when we have multiple electronic devices beeping, ringing, vibrating throughout our homes, announcing likes and shares, streaming content, and giving us news alerts, it's perhaps difficult to imagine a time when families huddled around a radio waiting to listen to the soothing tones of their president. But at a time when we ourselves are living through the ravages of the COVID-19 pandemic, we can perhaps relate to the need for comfort and reassurance at a time when we ourselves are gripped by anxiety and uncertainty. Throughout the pandemic, institutions, global institutions even, such as the ICC and the Chartered Institute of Arbitrators, have tried to do just that, to reassure us during a period of great uncertainty in global business and cross-border transactions. And they have done these in several ways, They have adapted their internal processes to make sure that they continue to provide the high-level services throughout this period. They have issued guidance notes to support arbitrators, parties, and counsel, and they've maintained a steady program of online seminars and conversations such as this one. Now, as some countries open up after successful vaccine campaigns, and others still are faced by successive waves of the pandemic, we see that we're threatened by nationalism. But we still see that despite these threats of nationalism and borders closing, we remain interconnected. And we're reminded of this in our work every day when we look at the nationalities of parties, the range of laws, and the seats of disputes that we see in our daily work in international dispute resolution. So now, as much as ever, as we're faced with our own interconnectedness in different ways than in the 1930s and 40s, we still require reassurance from our leaders. It's therefore fitting that we have two of the most prominent leaders in international arbitration today sitting around our fireside. I'm certain that they will not only reassure us, but inspire as well as challenge us. So huddle close, and don't forget to send us your questions for our leaders today, and listen carefully to our two presidents today. And after those opening remarks, it was with great pleasure that I introduce Ryan Robertson. Anne is a global president of the Chartered Institute of Arbitrators. She's an international partner at Law Claude LLP's Houston office and acts as counsel and arbitrator in a wide variety of complex business disputes. She is listed on the panels of many arbitral institutions around the world, including the United States, Singapore, Malaysia, Korea, and the British Virgin Islands. Anne has received many awards and honors throughout her career and has been named to Global Arbitration Review's Who's Who Legal Arbitration since 2015. She has also been recognized as one of the best lawyers in America in international arbitration and government since 2014. Anne is an adjunct professor at the University of Houston's Law Center and frequently speaks and writes on arbitration issues around the world. More recently, Anne has been selected by the United States Department of Trade as one of 10 arbitrators appointed by the United States to serve as dispute settlement panelists pursuant to Chapter 31 of the United States-Mexico-Canada Agreement, formerly known as NAFTA. As you will hear this afternoon, Anne is a long-time supporter of diversity in international arbitration and is one of the founding members of Arbitral Women. A warm welcome to you, Anne. This is a long time since our first meeting in Houston all those many years ago, and it's a pleasure to be in conversation with you this afternoon. Over to you, Catherine.
Thanks, Danga. And I'll take this opportunity to introduce Claudia Solomon. So Claudia Solomon is an independent arbitrator specializing in international investor state and complex commercial disputes. She's widely recognized as one of the leading arbitration practitioners of her generation. Claudia has experience as an arbitrator and counsel in some of the most complex, high value and significant disputes. Her cases span a broad range of industry sectors, including construction, energy and natural resources, including oil and gas, hydroelectric, solar and wind farm, financial services, hospitality, life sciences, technology and telecommunications. Claudia is particularly adept at multi-party, multi-contract claims involving complex financial agreements, post-M&A disputes, and intellectual property rights. Claudia has been recommended for election as the president of the ICC, International Court of Arbitration, effective from July 1st, putting her on the path to becoming the first woman president of the ICC court in its almost 100-year history. Claudia is fellow of the Chartered Institute of Arbitrators and is a sought-after speaker and writer on international arbitration, and is the co-editor of Choice of Venue in International Arbitration, published by Oxford University Press. Claudia is a member of the New York Bar and a solicitor in England and Wales. Claudia graduated from Harvard Law School, cum laude, and Brandeis University, summa cum laude, with honours. Claudia also studied at Somerville College, the University of Oxford. Claudia, thank you so much for joining us today. Danga, over to you for the first question. Thank you.
Thank you very much, Catherine. My first question is to you, Claudia, and we're going to get right into it. You have recently moved from a large international law firm to set up your own practice. Perhaps you could share with us what that experience has been like and give some tips to those who may wish to follow a similar path.
Thank you so much, Danga and Catherine. And to Anne, I'm just thrilled to be here and watching the chat and seeing where everyone is from. I still get a flutter of amazement that we really are part of this truly global community. And I recognize it's such a privilege, especially during this time where so many people feel isolated. So to kick off, and my start as an independent arbitrator, I left Latham and Watkins at the end of 2020, where I had been the global co-chair of the practice and had primarily worked as counsel, working with large teams and a small percentage of my practice as an arbitrator. And then with the start of the year, to assure that I had no conflicts with my work as president of the ICC court, I launched my independent arbitrator practice and won't have any work as counsel. I can't take any ICC cases, but I have been fortunate already to get some wonderful appointments under a wide variety of other rules, including cases, even under Indonesian law involving mining, insurance, complex financial arrangements, and energy. So my advice really to anyone who's looking to launch their independent arbitrator practice, and Danga, as an independent arbitrator, you certainly have wonderful advice for others as well. People really need to recognize that when they are launching an independent arbitrator practice, if they're not joining chambers or some other group, they are launching an independent business. They become a small business owner. So suddenly you have to work through all the issues of, do you need a corporate structure? What is your accounting program? What kind of technology setup are you going to have? What's your public profile? What is search engine optimization so someone can actually find you when they do a Google search? Fortunately, I had a great IT consultant who helped me tremendously, but it does take time to set up all of that infrastructure. And that's just really important for people to build in when they're looking to set up their practice.
Thank you very much, Claudia. I can certainly relate to the small business aspect of working as an independent practitioner. Thank you very much for those remarks. I'm going to turn to you, Anne, and we're going to go again right to the heart of it without much warm-up, and ask you, you've had a successful career in international dispute resolution. You've had different roles: counsel, arbitrator, adjunct lecturer. What stumbling blocks have you encountered along the way, and how have you overcome them?
Thanks for the question, Danga. And I am thrilled also to be here with my friend Claudia, whom I have known for almost 2 decades, I think. And of course, Danga and I have known each other for over a decade. And unfortunately, Catherine and I have only known each other about a year, but we have been working very closely in the past 6 months, and it's been a real joy to work with her. I just checked, and we have over 300 people on this webinar, which is fantastic. And I join Claudia in saying that it's wonderful to be part of such an international community. You asked me about a stumbling block, and I would tell you that instead of a stumbling block, it was more of a hurdle for me. And that hurdle was to actually get into the international arbitration field. Like many people that ultimately move into this field, I began my practice as a trial attorney with a large firm in Texas that did not have an international practice. And about 15 years into my career, I had an occasion to be a witness in an international arbitration. I was one of a team of lawyers that had represented a client that had entered into a very large settlement and ultimately had a dispute with one of its insurance layers over whether or not the settlement in fact had been reasonable. And we agreed that we would arbitrate that dispute in London. And I was very fortunate to have as the barrister that the client selected and instructed was the late Johnny Veeder. We had 3 men for the tribunal, many of which are still very active in the London community. And I was fascinated by the process. I was fascinated by the fact that there was no direct examination. I was fascinated by the fact that we were sitting in this very crowded room with piles and piles of paper around, and that it was all confidential, and that these three men were going to be making a decision that ultimately would result in an award of about $100 million. So I started investigating the process and how to get involved in it. And I realized that I was lacking something that I really needed, which was a foundation in international law. So I left the practice of law and went back to university and obtained an LLM in international economic law. And then I began to pursue my career. And I did that first by going to conferences. And it was very, very difficult to go to conferences where you know no one, but I forced myself to do so. I also had the great, it was actually serendipity, to meet the then chair of the North America branch, who informed me that they would be doing a training in Houston. And I took the training and it was fabulous. Absolutely one of the best courses I had ever taken. And I proceeded to take each course thereafter and to become active in the Chartered Institute, first as a branch member, then ultimately as the chair. Then I ran for trustee, and now today, of course, I am president. So it has been a long journey, but there was a huge hurdle to begin. And so as to stumbling blocks per se, I don't think there have been any stumbling blocks, because I've been involved in this, what I will call a marathon, for about the last 15 to 20 years to ultimately get to this point.
Thank you, Anna. I'm going to put a follow-up question actually to both Anna and Claudia, and I think it resonate with many of our younger practitioners who are perhaps starting out in practice. So what tips do you have for younger practitioners aspiring to similar positions of leadership in the field of international arbitration? Maybe put that to Claudia first.
Certainly. Well, before the pandemic, I used to offer packing tips to young lawyers, but I'm going to need some of those myself when we start traveling again. But perhaps before thinking about aspiring to a leadership position within the field of arbitration, you really have to get down to basics, and that's ultimately, to be a great lawyer. You know, as a young lawyer, you have to really focus on knowing the file, working to come up with the arguments and not just the problems of what the argument may face, and focusing really on the issues in dispute. And so in that context, you have to get outside of your comfort zone. And there's the old adage of, if you're not challenged every day, you're not really pushing yourself. And I do feel that each day, and sometimes think, why am I doing this? But realize how much I'm continuing to learn even now every day. But ultimately, in terms of building your profile and reputation and seeking and obtaining wonderful opportunities in the international arbitration space, my primary tip is you need to create your own opportunities. You need to figure out ways in which you can slowly, every year, identify one or two key things that you're going to do, whether it's write an article, try to attend and get more visibility in an organization, so then you ultimately get thought of as a speaker, volunteering with an organization to do things that others may not want to do, so that you become known as somebody who's reliable and can be and committed. And with that, in that context, I would say really pick an organization. You heard Anne, how she really built up her profile and commitment to the Chartered Institute. And it's the same for me with the ICC. You know, I was the first chair of the Young Arbitrator Forum when YAF was only within the United States. And of course, now it's global. And I went from that to serving on one of the task forces for reducing time and costs. I was the co-chair of the task force on financial institutions and international arbitration, which, by the way, is a task force I proposed, as opposed to just waiting for somebody to think of me in that context, and then, you know, ultimately selected as a U.S. court member, vice president, and soon to be president of the ICC court. And so maybe just my last key point on tips would also be to say, you know, have a plan B. And by that, I mean, just be flexible. The most interesting questions in law are questions that you have not yet studied in law school. Because if you've already studied them, they're not going to be the cutting edge issues in the future. And so while you may think that you are so focused on a very specific issue, like I want to represent states in investment treaty arbitration, be open to other opportunities. And it may be within the international arbitration space, it may be within international law, or something else that none of us even realize are going to become the most exciting and important issues in law in the future.
Thank you, Claudia. Really, really inspiring. And Anne, what would your be top tips for young practitioners aspiring to leadership?
Well, I, of course, would embrace everything that Claudia said. I think that's some excellent advice. In my opinion, the three most important factors in achieving success are passion, confidence, and action. And so many opportunities exist today that were not available when I started my ADR journey. I'm going to assume, for purposes of this question, that you have the passion. As for confidence, knowledge builds confidence. So I would suggest that you be an avid reader of ADR publications, many of which can be delivered to your inbox daily and for free. As for action, I would suggest that you have to push yourself out of your comfort zone. At conferences, seek out those who already enjoy success and watch and learn. If you're lucky enough to be under 40, and I can barely remember 40 at this point, and a member of the Chartered Institute, there's an extremely active young members group that just finished a worldwide tour of webinars. So volunteer to give presentations, or to research for someone, or write that article that no one else wants to write. And then, of course, as Claudia demonstrated through her journey through the ICC, become active in the local branch of the Chartered Institute or whatever organization you may choose. There is going to be a niche for you, and you need to seek it out. For example, the Chartered Institute is in the process of forming a member insight panel to gather the members' views to assist the Institute in delivering its strategy. This panel is open to all members from all corners of the globe and at every membership level. If you're interested, then that's something for which you should apply. I mentioned that I had been the chair of the North America branch of the Chartered Institute, and how that happened was rather unusual. I had been a member of the executive committee. The then chair of the North American branch was elevated to a judicial bench, in Canada, and could no longer serve. And I was drafted by the other members of the executive committee to take over his role and fulfill his term. Now, you might wonder why I was selected. I think I was selected because I was the one who had been willing to do all the minutia and difficult work that no one else wanted to do, such as setting up the training programs that the branch was offering. And in that, I was able to demonstrate my ability to organize, my ability to lead, and my ability to take care of details and be willing to step in when others would not. It is my personal belief that if you demonstrate dedication, that leadership opportunities are going to naturally follow.
Thanks, Anne. Really wise words, and I'm sure very inspiring for some of the practitioners that are aspiring to leadership positions listening in today. I'd like to sort of move on to something that I feel really passionate about, which is equality, diversity, and inclusion. And again, I'm going to put this question to both of you, but maybe this time we'll start with Anne. How important is diversity to the future of arbitration? And what progress do you think is being made in this regard?
Well, my personal opinion is extremely important. And the ADR sector faces numerous challenges improving performance around diversity and inclusion. Now, if we look at the issue of gender diversity as just one example, the figures from the ICCA Cross-Institutional Task Force on Gender Diversity and Arbitral Appointments and Proceedings demonstrated that in 2019, a little over a fifth of the arbitrators appointed in disputes were women. Now, that was an improvement of 10 percentage points from the previous report that had been issued in 2015. So I think we can take some encouragement from the fact that the numbers have increased. Much of the credit for the increase in this gender diversity is due to the Equal Representation and Arbitration Pledge, which I, and I'm sure Claudia and our particular firms were early signatories to, which has since 2015 actively worked to improve female representation in the profession. I think it's important to note, however, that the success seems to have been strongest with institutional arbitration appointments, where women comprised approximately 30% of all appointments last year. We have to compare that to the party-appointed arbitrators, in which we find that only 14% of the appointments are women. So there is much to be done in the area of educating the end users, or as Claudia likes to call customers, regarding appointing women as arbitrators. For other forms of diversity, one of the key challenges is always going to be access to adequate data. One of the only available metrics that's around right now, of course, is nationality. And institutional figures seem to generally show that appointments are heavily weighted towards Western European arbitrators. And this is something that I, being located in the United States, would like to also see a great deal of improvement. And I think it's important that we have arbitrators from all aspects of the world, all geographical aspects, to be appointed. The Chartered Institute wants to take a proactive and ambitious approach to improving diversity. And its new equality, diversity, and inclusion strategy sets out a number of actions that the Institute is going to be taking, including developing a new mentoring program targeted at underrepresented groups, and in improving the quality of the Institute's data so that we and others can make properly informed decisions. It is an education process. It will take time, but it does now have the momentum it needs.
Thank you, Anne. Claudia, how important do you think diversity is for the future of arbitration?
We can do more, we must do more, and I sit here today to say that increasing diversity in international arbitration is an absolute priority for me, and we will do more. I look back at some of the lists I prepared for clients to consider potential arbitrators just recently, and see that how homogenous the potential candidates were, and that there wasn't diversity there, and that absolutely has to change. It's exciting to see the demand for diversity coming from in-house counsel for their outside counsel, but in-house counsel and the business community are demanding diversity in every aspect of their services, and that includes the international arbitration community as well. And so the international arbitration community must reflect the world in which we serve. Alexi Moore, the current president of the ICC court, must be commended for the work he has done in achieving gender parity on the ICC court and his focus on gender diversity in terms of arbitral appointments. Of course, diversity is broadly defined, and the work on gender diversity, given the statistics that Anne just described, is not done. But we have to be focused on not only gender diversity, but race and ethnic diversity, geographic diversity, age and socioeconomic diversity, LGBT, and what is going to be a priority for me, disability inclusion. As I said, this is an imperative in the context of legitimacy of arbitration. It's essential for capacity building, training, and organizational leadership. And I would just say, you know, in some respects, I think, especially in gender diversity in some parts of the world, I think there's a feeling like maybe the work is done. But just last week, for an organization that's not the ICC or the Chartered Institute, there was advertisements for a program involving experts, and the entire panel, including the moderator, was white men. And you know, when we approached the organizer, he said, well, I wanted to have all experts who had appeared before me, and I hadn't had any women appear before me. And so we needed a shift of mindset to recognize that the actual criteria for organizing the program was flawed, because the premise that there weren't any women experts having appeared before you, even though there are phenomenal experts in the field, is the actual issue. So we have to keep at this in every aspect of work we're doing in this community.
Couldn't agree more. So thank you, Anne and Claudia. Danga.
Thank you, Catherine. I'm going to turn to a topic that's very important in international arbitration, but not always one which is popular amongst the arbitration community. And that's the topic of ethics in international arbitration, or amongst, or the ethics of arbitrators even. Now, Yves Derrand, in a speech a few years ago, famously stated that an important quality of an arbitrator is not to need approval from the parties. Now, this is often at odds, or this quality is often at odds with an arbitrator's desire to get reappointments. And unfortunately, there does not exist around the world a single document that sets out the types of, or the type of conduct that is expected of international arbitrators. So this is a question for you, Anne. The Chartered Institute introduced a Code of Professional and Ethical Conduct in 2009. That's more than 10 years ago. What has been the uptake in the use of this document? What do you see as its future? And what do you expect, perhaps, when we see other documents coming up from, for example, ICSID and ANSITRAL defining a code of conduct? What do we expect to see in this field with respect to codes of conduct and their uptake in the community?
Well, I think the idea of a code of conduct is especially important, and actually the fact that the Chartered Institute has one and has had one for over 10 years is a point of pride for us. And I want to start out by saying that we have, as Catherine said, over 17,000 members, and our code of conduct is applicable to each and every member. And the purpose of this code of conduct is to ensure market confidence in the integrity of the Chartered Institute accredited professionals. And while the Institute's not a regulatory body, our members can indeed be held accountable against that code of ethics. And if they commit a serious enough breach, can be expelled from the organization. Looking ahead, if we are to promote the wider use of arbitration and ADR, it's imperative that the users, or as Claudia says, the customers, can have that level of confidence. It is key. And my vision is that the Chartered Institute's accreditation will become more valuable under those circumstances as users increasingly demand the quality assurance that the Chartered Institute post-nominals and the ethical code that they denote provide. And in a rapidly changing world, of course, it's also vital that our code of ethics reflects the environment in which our members operate. And the Institute is continually looking at ways in which the code can be improved. I would like to give a personal example of the power of the post-nominals. Back when I was studying for my LLM, I received a fax, and the fact that I received a fax tells you how long ago that was, from an individual that I had never met, asking me if I would undertake a representation of his client. Now, this individual did not live in the United States, and in fact, I threw the letter in the trash thinking perhaps it was some sort of scam. But then I began to reflect because I realized that his letterhead indicated that he was a fellow of the Chartered Institute. So that told me that he had been vetted by a particular organization and that he was held to a code of conduct. So I contacted him, and the result of that was that I actually undertook this particular representation. It was one of the most exciting lawsuits that I was ever involved in, and we created new law in Texas in that lawsuit. Now, that was an opportunity that would have been lost to me had I not pulled that particular letter out of the trash. And the impetus for pulling it out of the trash was the fact that the author of that particular letter had behind his name FCIArb. So for those that understand the importance of those postnominals and the fact that we do have a code of conduct, I think will give great assurance and comfort to the users of ADR throughout the world.
Thank you very much. And I have a follow-up question for you. You mentioned the disciplinary role of the Chartered Institute, and it has this role through its jurisdiction to hear and determine complaints from members. How often is this jurisdiction imposed, and do you expect to see an increase in the CIArb exercising this jurisdiction in the coming years?
Well, Danga, to answer that question, it might be helpful for me to briefly explain that disciplinary rule. The Chartered Institute bylaws establish the Professional Conduct Committee, and this committee can consist up to 9 members, 2 of which must be lawyers, and 1 must either be a judge or a former judge. An additional 1, and not more than 5, are lay members. So the code of conduct is being determined not only by members of the ADR profession, but also by those outside the profession. The committee investigates all complaints against any member, and if the committee is of the opinion that the complaint is insignificant, the committee has the power to dismiss it. However, if the committee is of the opinion that the complaint is significant or discloses prima facie evidence of misconduct, there are due process safeguards in place that allow for a full hearing before a tribunal. Now, at present, the Chartered Institute does not publish these reports of the disciplinary proceedings other than with the consent of the Board of Trustees. And the volume of complaints received that proceed to tribunal is low. In fact, in my 7 years on the Board of Trustees, I can only remember 2 times in which the Board of Trustees was called on to make the decision as to whether or not the disciplinary proceeding would be published. It's important to note, however, that in the past, the Institute has expelled members from the Institute, including a former president. The Chartered Institute obviously hopes that all people who engage with our members receive a positive experience, but the Chartered Institute treats all allegations of misconduct seriously. And so for those that are users of arbitration, they can take some comfort from the fact that in fact there are those postnominals, just as I did when I pulled that letter out of the trash so many years ago to undertake that representation of that particular client. Of course, it would be our hope as the Chartered Institute that we would get more and more members, all of whom would be subject to this conduct, code of conduct, and we would help to continue to raise the bar of professionalism in the arbitration field.
Thank you, Anne. I'm going to continue on the disciplinary theme with Claudia. The ICC has always been at the forefront of innovation, and we'll recall that it caused waves in the field when it announced in 2016 that it would reduce the amount of remuneration of the arbitrators who had unjustifiably rendered late draft awards. Could we see innovative measures from the ICC in the future with regard to disciplinary action against arbitrators?
Yes, Catherine, just to elaborate a little bit further on the reduction of fees, that did indeed cause waves when the policy and approach was announced, but I would say it caused waves with the arbitrators, not the parties. And so what we have seen once this policy was put into place is that yes, the arbitrator fees are reduced if they do not issue their award within 2 months as a sole arbitrator or 3 as a 3-person tribunal, unless there's particular circumstances that warrant additional time. But the consequence and the objective of such an approach is not to reduce arbitrator fees. It's to reduce the time in which awards are issued, and the effect has in fact been exactly that. We have seen awards get issued faster and seen fewer late awards. I do expect the system to get refined. Of course, we have some situations where, arbitrators may rush to get a draft award submitted within the so-called deadline, but then the draft isn't very good and the court may not approve it. And so the question arises as to how to address that issue. There is also the question of discipline, or somehow having an arbitrator on what has in the past been called a blacklist, even if that's an inappropriate term now. In other words, where the institutions know that the arbitrator has not performed in the way that is expected, and yet that arbitrator is nominated by the parties. The ICC has that role of reviewing the nominations and then confirming appointment. So in those circumstances, if a party wants that arbitrator, but the institution has the memory and the knowledge of experiences in the past, there is that question of what to do in those circumstances. And then do you take away party autonomy, or is there the expectation of the party to have, that's why the ICC then actually has the final determination about whether the arbitrator should be appointed. Tough questions that are very fact and case specific. Lastly, just to mention, there is that ability of the ICC to replace an arbitrator who is not performing as expected. That is a rare circumstance, but it does happen when the arbitrator is in essence giving the institution and the field of international arbitration a bad name, and ultimately threatening the legitimacy of international arbitration. And that is why the power of the institution is there to address those circumstances.
Thank you, Claudia. I'd like to just maybe focus on the issue of conflicts, and maybe put this question firstly to Anne. So both CIArb and the ICC argued in Halliburton and Chubb for the recognition by the court of a legal duty of disclosure, which the English Supreme Court agreed with. Do you think that because of this case, we'll see more disclosures in the future by arbitrators? And if so, presumably this is a good thing? And what's your view?
Well, as you noted, Catherine, the Chartered Institute, in fact, did intervene in the Halliburton versus Chubb case to hopefully address the issue of impartiality in the practice of arbitrators in disclosing matters which might give rise to doubts of their impartiality. And of course, the tensions that might arise in cases of multiple appointments, given the confidential aspects of arbitrations. And I think that this particular decision was a good one. However, I think that we should not be so myopic to think that Halliburton versus Chubb, in fact, has set the worldwide standard, because as we know, there is no universal application of the standard of independent and impartial. I give for you some examples from the United States. The last time the United States actually spoke on the issue of arbitrator disclosure was in 1969, which is probably before many of the people that are listening to this webinar were even born. That case was Commonwealth Coatings. I refer to this case as a gray case because it was a plurality plus decision with both Justice Black and Justice White writing opinions. Its application to any particular situation can vary widely. And I always like to give the example of the positive software case from the Fifth Circuit in the United States. Now, the Fifth Circuit is comprised, well, Texas is in the Fifth Circuit, which is one of the reasons I'm so familiar with the positive software case. In positive software, the arbitrator and the former firm had several years previously represented the same client as one of the attorneys for the parties in the arbitration. Now, this client was not a party to the arbitration. We literally just have two lawyers that had represented a common client. This common client had been involved in 6 different lawsuits, and the arbitrator and this counsel were 2 of at least 34 lawyers who had represented this common client. Now, although their names appeared on the pleadings, the arbitrator and the counsel had never attended or participated in any meetings, telephone calls, hearings, depositions, or anything. It was just the aspect of having your name on the pleading. The losing party in the arbitration, which so often happens, unfortunately, began an investigation after having lost and learned of this common client representation, and based solely on that common client representation, filed a motion to vacate on the grounds that the prior relationship might have conveyed an impression of possible partiality to a reasonable person. Now, so the district court has now vacated that award, and that decision is appealed. And on appeal, it's affirmed. However, a motion for rehearing en banc is now filed. And on the en banc ruling, reversed the trial court, stating that awarding vacatur in such a situation would seriously jeopardize the finality of arbitration. Now, what we have here are justices from the same appellate court that cannot agree, faced with the same facts, on whether or not a disclosure should occur. Now, the IBA guidelines on conflict of interest have attempted to bridge this gap and provide some sort of universal basis for disclosure. But first of all, it cannot answer every situation. And secondly, I happen to know that in the United States, every time that those particular rules are cited, the courts have said, however laudable, it is not the law in the United States. So in my opinion, there is much to be done in this area of disclosure and conflicts of interest, and to hopefully at some point reach a universal basis on what needs to be disclosed. And each new judicial decision from whatever jurisdiction, I think, will hopefully inform and provide greater clarity on this extremely important topic, because it is indeed a foundational precept of arbitration.
Thank you, Anne. Claudia, your thoughts on conflicts, Halliburton and Chubb disclosure?
I do expect that there will be more disclosure in the future, and I do expect that there's going to be a need for greater clarity, as Anne was describing, either provided by the institutions or some other system. Because what we have right now is a patchwork of approaches and different expectations of the parties as to what will be disclosed. The ICC has now announced that it will provide reasons for its decisions regarding challenges to arbitrator appointments. And right now, the decisions are only provided to the parties, but as more decisions are provided, there will be that opportunity in the future to provide a compendium of these decisions appropriately anonymized, but that's going to give the public an understanding of the ICC's approach to these issues. Why is that important? It's not just intellectual curiosity. By having an understanding that's made public to everyone about the approach, I expect that there's actually going to be less challenges in the future, because it's going to mean that everyone's going to have an understanding or an opportunity to understand that if they appoint someone that has certain conflicts or conflicts as assessed by the ICC, there's going to be a legitimate basis for challenge. And that should actually operate as a way of preventing or discouraging such appointments. And so I do think that this transparency of approach is essential to the legitimacy of arbitration, but is ultimately going to impact and result in less challenges. These issues are incredibly sensitive, evolving, and fact-specific. One of the, let's say, hot topics we have in challenges and disclosure right now is the question of repeat appointments. And how should institutions be assessing repeat appointments in markets where there are fewer arbitrators and fewer people qualified in this arena, or maybe people who have primarily worked for the government in the past? How does that impact their selection in that market or in an arbitration involving parties from that jurisdiction compared to other places? Should the assessment of repeat appointments be jurisdictional relevant and specific, or should there be a universal? These are questions that we're all going to need to grapple with together.
Yes, no, thank you, Claudia. I think the issue of transparency and the issues we touched on earlier around ethics, I think, you know, are particularly relevant, and I'm sure there'll be more to come in that area. Danga, I'll hand over to you.
Thank you very much, Catherine. So we're getting to the part of this conversation where the audience should huddle closer as we look to the future. And I have a question for both Anne and Claudia, and perhaps we can start with Anne. What areas of collaboration can we expect to see between the ICC and the Chartered Institute in the coming years?
I think you know from the remarks that both Claudia and I have made today that both organizations are committed to improving diversity and inclusion within the profession and ensuring that talented people of all backgrounds can pursue a career in dispute resolution and, more importantly, truly flourish. In addition, I think there are other areas of common interest in which collaboration could be beneficial. For example, as we look towards the post-COVID era, and it looks like it may be getting closer than we thought, we will all keep our fingers crossed on that. The Institute is emphasizing how businesses of all sizes can benefit from using ADR and arbitration to deal with disputes rather than resorting to litigation. And this is at the heart of both of our organizations. It's what both organizations stand for. In other areas, we're committed to, of course, improving diversity and inclusion in the profession. And I think this is especially an area where collaboration and cooperation across the sector could be particularly valuable. And we at the Chartered Institute, and I'm sure that it's true with the ICC, are committed to equipping the profession for an increasingly tech-oriented world. And this is another area where there could be collaboration regarding what should be those best practices and how do we go about facing in this tech-oriented world when we are trying to resolve disputes outside the court system.
I can just add to that, as Catherine mentioned, the ICC and the Chartered Institute of Arbitrators have a shared history a shared mission founded with the same goal of promoting international arbitration as an effective way of resolving disputes peacefully. So I do intend to build on this collaboration, and just thrilled that we're off to such a start. We'll be focused on promoting arbitration and capacity building and training, especially in Africa, which is a priority for the ICC. The ICC is also, of course, focused on helping business worldwide, and there is a particular focus on SMEs and MSMEs, small and medium-sized enterprises and micro-sized businesses, and they have been particularly hit in the pandemic. And so there is an absolutely essential need for SMEs to have an effective, cost-effective means of resolving their disputes. And this is an obvious way in which the Chartered Institute and the ICC will be able to work together in that regard.
Thank you very much for those responses. You know that we will be looking out for the announcements of those initiatives, all 300 and something of us listening in. So all the best with actually concretizing those ideas. And before I hand over to Catherine, just to remind the audience that we'll be moving to Q&A soon. So please do ask your questions using the Q&A button rather than the chat button. Catherine, over to you.
Thanks, Danga. So I guess the final question before we get on to the audience's questions, and I'm going to put this question to both of you because I think it's a very important question. As we look around the world, the climate emergency is high on the agenda, and I think it's imperative that organisations like ours are proactive and play a practical role in tackling the sort of climate change emergency. What are your views on how the profession can reduce its carbon footprint, and what role can CIArb and the ICC play in leading on this change? Anne, would you like to?
Yes, I'll be happy to start out. We're all in this brave new world now of a lack of paper and having webinars such as this one. And I actually did my first case remotely last summer as an arbitrator. And I like to think that I'm getting better and better at it. And I think most people feel that they're getting more comfortable with this medium. And it is obviously here to stay. I'd like to point out that at the outset of the COVID lockdowns last year, the Chartered Institute issued a remote proceedings guidance note to assist practitioners with dealing with online hearings. And while remote proceedings do bring their own set of challenges, it's the Institute's view that they need to be a permanent part of the arbitrator's toolkit, not only to meet the needs of this current crisis, but also to actively tackle the climate crisis. And of course, if used intelligently, they have the potential to significantly reduce the carbon footprint our profession has made on the world and greatly increase efficiency and cost effectiveness for the parties. If you think about arbitrations pre-COVID, there was always bundles, which were usually stacks and stacks and stacks of paper. You were shunting all around the world on airplanes, and it was the exception rather than the rule that a witness would appear remotely. And in those instances, it was usually because of illness or visa issues. As I made clear in a debate that I had earlier this year, sponsored by the Asia International Arbitration Center, climate change and efficiency both have to be at the forefront of our minds as we grapple with this issue. I know also that in addition to the remote proceedings guidance note, that the Chartered Institute is currently working on a guideline for sustainability and dispute resolution, which will build on the insights in the remote proceeding note to provide a more encompassing toolkit for reducing the environmental impact of dispute resolution right across the full duration of that particular process. It's going to be a thorough, practical guideline like this to allow that the institutions can lead the way in allowing the profession to adapt not only to this idea of remote hearings generally, but also to play our part in the climate change challenge. The Chartered Institute is also supportive of initiatives like Lucy Greenwood's Greener Arbitrations, which is encouraging practitioners to face this issue head on. It makes us realize how just one arbitration can have a tremendous impact on the environment. But most importantly of all is that we all as organizations and as individuals have a part to play in addressing this most important issue.
Thank you, Anne. Claudia.
Before the pandemic, I used to joke that we should plant a tree, after each arbitration, because I felt like just given the amount of paper we had printed and thrown away, that was at least some recompense. But what Lucy Greenwood and others have done is actually quantify the actual impact and the carbon impact of each arbitration, and then giving us specific tools to address that. And that's so valuable. Because it's raising the consciousness. Again, before the pandemic, I remember going to one of the hearing centers and everyone was using plastic bottles for water. Now, that's not the case in London. There's nice glasses. And I understand kind of the desire for a water bottle or at least something that has a cap, because in a moment in an arbitration, the worst thing that can happen is your arm goes across the desk and suddenly there's water everywhere, so there is a desire to have something with a lid. And my idea had been, why not, when parties rent the hearing space, they get logoed water bottles, and then there'd be a water cooler, and suddenly there'd be thousands of less water bottles, plastic bottles for each hearing. That's not something that got implemented before the pandemic, given the conversations about the impact of arbitration. I just can't imagine us going into an arbitration hearing utilizing that level of plastic any longer. On a personal level, I couldn't imagine chairing an ICC committee session or handling an arbitration without hard copies. And as a result of the pandemic, I have gone completely electronic with my documents, and I have learned how to do that. And so the pandemic has been a horrific experience globally, but there has been a set of learnings that we have to take from the experience that we've had and continue those after we emerge from this experience.
Thank you. I think that's, the climate change is something that will be on the agenda, for the next few years, and I'm sure it's something that we keep talking about. I'm going to change now to maybe address some of the questions that have been put in the Q&A box, and maybe, if I may, Danga, I'll sort of kick off with the first one, which I think is actually quite relevant to what we've just been talking about, and it's from Andrew Parsons, who, if it's the Andrew Parsons I know, is one of our branch chairs. So thank you for the question, Andrew. How have you adapted your practices in the new COVID-19 world? I'll maybe put that question to both of you. Maybe Anne, what adaptations have you made?
Well, the first adaptation I have made to this brave new world, and leave it to Andrew to put a question like that forward, is that my dining room is now my office. And I have gone from utilizing 2 monitors to utilizing 3 monitors, and actually I'm thinking about getting yet a larger monitor than the ones that I have at the moment. Claudia and I were laughing before this all started about how we've become adept at lighting issues that we never would have thought that we had to do. And these are all the physical things that we've had to do to adapt our practice. In addition, as Claudia had mentioned, I'm not killing trees anymore. I'm actually now utilizing electronics much more than I did before. I've learned that I can do that, where before I felt I had to have a hard copy for everything. And now, unless it's a chart, I admit I still print charts, but if it's just written words, I can usually do it on the computer without any problem. And I think the other change has been that, you know, in the last year, I've become fairly adept at Zoom and Skype and Blue Jeans and all the rest of the platforms that are being used. And I think it's important to realize I've just named 3 or 4, and that's going to be one of the challenges going forward, is that there is no universal platforms that are being utilized. And so if you're going to be, for instance, the advocate, you're going to need to know what the arbitrator uses, what the arbitrator is comfortable with, and adjust. So there's going to be a lot of adjustments yet, especially in the advocates area, about how you can be more effective as an advocate. And of course, there are many theories on that as well. But all in all, the main change has been my commute for the last 1.5 years has been from my bedroom to my dining room. I see my husband 24 hours a day, and I'm doing everything electronically.
And my experience is very similar, as we're all working remotely, but just to build on that, one of the aspects of this pandemic is that, in essence, we've all been disabled. In other words, we have not been able to work in the same ways that we had previously been, because we can't physically get to the places we're used to going. And so I say that we're actually at this incredibly pivotal moment in history where we're not going to go back to the way it was. And so, as I was saying, we have to take what we've learned from this pandemic and shape the way we operate in the future. So before the pandemic, if somebody couldn't travel to a hearing, they may have thought that international arbitration was not a field for them, or that they would have so many challenges to get into the field. Now we see that people who can't easily travel can still be incredible advocates. Similarly, in the past, if somebody couldn't work 8 hours a day at a hearing, we would consider that to be inefficient and might have been dismissive. Now, everyone's thinking, I can't be in front of a screen for 8 hours. So we've had to get to know people's personal circumstances in ways that before we considered that inappropriate. So let's take that and be conscious of people's personal circumstances. At the start of a hearing, for example, or start of an arbitration at a preliminary hearing, let's begin to add questions to our agenda, just like we now ask, are there GDPR issues we need to consider? Are there confidentiality issues we need to consider? Let's easily ask questions like, are there any disability inclusion issues we need to consider as we structure this arbitration? That basic question that we take from the learnings of this pandemic can shift the conversation from the person with a disability having to be the person asking for the accommodation to the arbitrators in the institutions, making the situation far more inclusive.
Thank you. Danga.
Yes, there are a series of questions related to non-lawyer arbitrators, and I think it might make sense to take them all at the same time. And so the first is how to set up a practice as an independent practitioner when you have a non-lawyer background. There's one that asks, is there a space for non-lawyer arbitrators in this field? And the final one digs a little bit deeper and asks what your views are on non-lawyer arbitrators, and further asks, is the exclusion of non-lawyers in diversity initiatives a matter of concern for Anne and for you, Anne and Claudia? And one of the initiatives that's listed is the ICA cross-institutional task force on diversity. I don't know who wants to start.
I'm happy
Claudia,
to
go
jump
ahead.
in.
Yeah, please, yes.
I'm on a panel now as chair in a insurance-related arbitration where one of the co-arbitrators is not a lawyer. And so there is the balance of having lawyers and non-lawyers on that case, someone with industry expertise, but then folks who are going to really be focused on the legal issues associated with interpretation of the contract. And it's something the parties wanted as a mix of experiences in assessing this case. So I think particularly in insurance, technical issues, accounting, there are construction, there's real room for non-lawyer arbitrators. And I know in particular, there is strong arbitrator organizations in Africa involving non-lawyer arbitrators. And we need to be inclusive of everyone with those experiences, because especially for small and medium-sized disputes, but also for very large ones, there are ways in which the non-lawyer arbitrators can really make the resolution of the dispute cost-effective when the crux of the question is not actually a legal question.
Thank you, Claudia. Anne, would you like to add something? Yes, please go ahead.
I would like to add, and I certainly agree with everything that Claudia said. And in fact, that case I mentioned, so many years ago, that got me interested in international arbitration. The chair happened to be an insurance specialist. But it was also evident during that arbitration that he really didn't have any arbitration experience. And so here's where I'd like to plug for the Chartered Institute of Arbitrators, because we have a membership that is comprised of many people that are not lawyers. And they have all taken the training that the Chartered Institute offers. And we have training that's specifically designed for non-lawyers to ultimately understand the intricacies of arbitration and to be able to have those post-nominals behind their name. So for me, the fact that someone is or is not a lawyer is not, especially in particular areas like construction and accounting and insurance, and I'm sure we can come up with a whole list of specialties, is not particularly concerning. What is concerning is the need to know the procedures and the ins and outs and what's important. And that is something that the Chartered Institute can supply, so that when you have a person that is an accountant and they have those post-nominals behind their name, you know that they understand the workings of arbitration.
Thank you, Anne. I'll just sort of shift subject matter a little bit. And I see there's a question from Anushka about third-party funding and contingency counsel fee arrangements in arbitration. And sort of then an open question about legality and concerns. What are your thoughts about third-party funding in arbitration? Maybe Claudia?
I would just answer the question in connection with the discussion we had about disclosure, which is that under the new ICC rules, there is a requirement to disclose third-party funding. And I think that's an essential piece of transparency and legitimacy in arbitration, so that when arbitrators are proceeding with the case, they know who is involved, because there could very well be advisors or other key people involved with the funder who have a significant connection or some other relationship to an arbitrator that the other party would need to know. So I think that's an important step. And I put that in the context of one of the investment treaty cases I had less than 15 years ago. And just to say how the world of third-party funding has changed so significantly, we're in a hearing and, you know, there's a need to disclose everyone in the room. And in an afternoon, I realized there's someone at the other party's counsel table who I didn't recognize. And we asked the tribunal to ask the other side to provide information as to who was this additional person. And there was a lot of whispering and activity at the table. And then the first response was, oh, this person is a friend of the claimant. And we asked for a little more information, and it turned out the friend was in fact a third-party funder. And so that's how quickly and far we've come in terms of expectations about third-party funding and a recognition that there really is a need for disclosure in this regard.
I might add to what Claudia had to say about third-party funding. It's here to stay. And I think it, in fact, provides a very important service, because it does allow parties that might not have the financial wherewithal to bring a claim, to have the ability to bring the claim. What we're seeing, however, is a bit of a shift in that sometimes we now see that in-house counsel are utilizing it to monetize claims. But it is definitely here to stay, and disclosure is the most important point on third-party funding. And the ICC, of course, requires disclosure, as do many other of the institutions. Sometimes those institutions leave it up to the arbitrators to make that inquiry of the parties, but nevertheless, it's to the forefront of everybody's mind. Regarding illegality, we have seen over the last 5 years a number of countries that have come in and amended their laws so that there will be no question but that third-party funding can be permitted. And so it does provide a very important service, and it provides access to justice. But at the same time that it's providing access to justice, we need to make certain that it does not undercut the foundational purpose of arbitration and the fact that it is to be determined by an arbitrator who is impartial and independent.
Thank you, and thank you, Claudia. Danga.
Yes, there are a series of questions on diversity, and I'll ask a couple of them to start with, and maybe we can see if we have time to go to the others. And the first is how you manage diversity in the context of privacy, how you balance those two in an instance where you require the arbitrators themselves to disclose what characteristics they have that are diverse, and how that interacts with domestic legislation in countries such as France, where the disclosure of certain characteristics may run afoul of the law. The second part of the diversity question from this attendee is to do with the definition of diversity in different geographical regions. So while being Hispanic in the United States might be a criteria for diversity being a minority, in Latin America, that's certainly not the case. And I think that applies elsewhere in the world as well. What's your response to that in the context of the initiatives that your institutions will be taking around diversity? We can start with Anne, perhaps, and then move to Claudia.
Well, I think this does highlight one of the issues as to, it goes kind of back to the, there's the old story about the blind man and the elephant, and the first blind man holds on to the trunk and he says, oh, it's like a snake. And the second one hangs on to the tail and says, oh, it's like a rope. And the third one hangs on to the leg and says, oh no, it's a tree. And what constitutes diversity is always going to be seen through the prism of the person that is making the decisions. And you're absolutely right. In Texas, Hispanics, they are a minority, but in Spain, they would not be. Latin America, they would not be. And so I think that what you have to do is to just it's all about giving information so that people can then make informed choices. Now, I take your point about the fact that France has laws about certain things cannot be disclosed. And I'm not that familiar with the French law, but obviously, for instance, arbitral women, you're allowed to list whatever you want to list, and you can list those things as the individual and give people access to it. So in that respect, it becomes a personal decision of the person who's looking to be appointed, whether or not they want that information out in the arbitration marketplace. You can tell typically by names as to gender. I say typically because I have found myself going to LinkedIn to try to figure out if someone was male or female when I'm unfamiliar with the name and the dialect. And sometimes they fortunately have their picture posted, and that helps. But there again, on LinkedIn, you can voluntarily put that information forward. And I think we need to realize that, in fact, there are many, many sources of information when people go to appoint an arbitrator. It is not just calling up people now. It is going to the internet. It's looking to see what's been posted so that these people have the ability, if they want, to let the marketplace know.
And just to build on that very briefly, there is no inconsistency here between promoting diversity and privacy, because in the context particularly of disability or LGBT or any other personal attribute, it is for the person themselves to determine whether they wish to disclose that information or not. We recognize, particularly for non-visible disabilities, that many people wish to keep that private, and they are, of course, it is their right and entitlement to do so. So the issue that you highlight about diversity in one space may not be diversity in another really goes to the core of what we're striving to achieve, which is diversity broadly defined, that the world and community of international arbitration reflects the global world in which we serve.
Thank you very much, Anne and Claudia. There's another couple of questions that can perhaps be classified as concerns about harmonization. And the first of these is to do with defining a code of conduct. And the question here is, shouldn't there be considerations about different cultural and domestic characteristics around the world when defining what constitutes the code of conduct or the elements of the code of conduct? So that's the first part. And then the second question around harmonization is, do parties in different sectors of industry have a right to expect different approaches to the question of repeat appointments and overlapping appointments? So if you can take those two, I hope they were clear, and if not, I'm happy to repeat them. And maybe this time we start with Claudia.
Well, certainly the Chubb decision in the UK recognized that different arbitral institutions, different sectors have different approaches to disclosure. So there is that kind of core recognition about different approaches. That said, I think there's a real risk if we have winds toward nationalization or localization of processes, because they're hopefully, in the context of legitimacy of arbitration, an opportunity for anyone entering a dispute with anyone around the globe to have a set of expectations about how the arbitration will proceed, and not surprises to say that, oh, well, there's someone from X country who is then going to operate differently. So that is an essential aspect of arbitration, while at the same time recognizing that there is an absolute need and demand at this point that the global aspect of arbitration also reflects local community, what's being termed as glocal, global and local, or as we say in the US, all politics is local. Even at the national and international level. And so that is really the balancing that has to take place in each case, and as we're structuring and thinking about processes going forward.
I agree with what Claudia has said, not surprisingly. I do think this is a very important point. I would like to raise a point, though, and this goes back to the Chartered Institute's Code of Conduct. And remember, we talked about the fact that you could have a tribunal. And embedded in those bylaws is that if there is to be a tribunal, that there has to be someone from the region involved in that hearing. And when I say from the region, I mean, if in fact I was the person that was to be before the tribunal for having violated the code of conduct, there would have to be someone from the United States, so that in fact it is viewed through the prism of the locale. But that being said, there is nevertheless a universal standard that I think needs to be applied. You know, I read a lot of decisions, and disclosure is one of the areas in which I'm very interested. And there have been some decisions in the last 2 or 3 years coming from areas of the world that are known for having robust arbitration centers. And I've been surprised by some of those decisions relating to disclosure. And I always try to guess what the decision is going to be before I actually get to that part of it. So there is much work that needs to be done. Fortunately, we've gotten away from the idea, you know, in the United States, it used to be, at least in the domestic arena, that the wing arbitrators were actually could talk ex parte to the party that appointed them. And that's been eliminated. It's been moved to the universal standard that, in fact, they have to be impartial and independent, and there's to be no ex parte. So I welcome decisions like the Chubb decision. I would like to see the United States take on another decision, and some of the other leading countries, so that perhaps we can come to more of a universal understanding of what it means to be impartial and independent.
Thanks, Anne, Claudia. I think we've probably got time for one final question, and I'm just going to pick up and slightly adapt a question from Tatiana. So Tatiana has recognised that we've had a very broad-ranging conversation about virtual hearings, use of technology, and some other issues. But are there any other topics which either Claudia or Anne think are sort of very relevant and important to the global arbitration community that perhaps we haven't touched on? Are there any final thoughts that you'd like to add to this discussion on areas that perhaps you see as important, but perhaps we haven't had the opportunity to discuss today? Maybe Claudia, would you like to comment?
Certainly. Really, one of the key themes of my presidency of the ICC court is going to be international arbitration with a client mindset, as Anne mentioned. And that is a perspective that everyone in the arbitration community, not just outside counsel who have clients, but the arbitrators and the institutions having a mindset that the parties have a central role in the arbitration. And some of this is as basic as communicating with the parties in the first communication, asking whether anyone from in-house counsel or other party representatives want to be copied on communications that come directly from the institution or from the arbitrators. It brings them into the conversation in real time, communicating that they are encouraged and invited, but of course not required to attend preliminary hearings. So their concerns, their focus on timing and risk assessment can be taken into account in the arbitration. And then just recognizing that parties are in an arbitration, not because they want to be in an arbitration, but because they want to resolve a dispute. And so thinking about that ultimate goal and whether there should be built-in timeframes for pauses within the arbitration to allow time for negotiations, or other ways to think about making sure that in the drive toward harmonization and in the drive toward efficiency and reducing time and costs, we haven't, lost sight of the forest from the trees as to what ultimately we need to do in administering and deciding cases.
And I think we have time for me to add 1 minute to that. And I think a corollary of that, we've been talking about arbitration, and we should not overlook mediation and the importance of the Singapore Convention, which is in its infancy, but no doubt will increase in importance. And I think mediation and arbitration go hand in hand, and they each have an important part to play in dispute resolution. And I anticipate that you're going to see more institutions, arbitral institutions, embracing the concept of mediation. I know the ICC has had its mediation moot now for 15 years at least. Other institutions actually have robust mediation rules to be utilized. And of course, it is a cornerstone of the Chartered Institute as well. So I think that we need to think about the fact that there are many different ways to resolve disputes. And I think that this whole theory of dispute resolution is in fact going to become much broader as we use differing techniques over the years.
Thank you so much. Thank you, Anne. Thank you, Claudia. Thank you, Danga. What a fantastic discussion, and what a fantastic chat as well. I've been loving the comments in the chat, and I don't know if there's any final comments that anybody wants to make, but I just want to say a massive thank you for your contribution and the discussion. It was fantastic, and I really enjoyed it and learned a lot. It was brilliant. So thank you.
Thank you so much, Danga, Catherine, Anne, and for everyone participating. We are craving these human connections while we are all isolated. And while this is no substitute for gathering in person, I do feel the connection to each one of you and really look forward to connecting in person in the future. Thank you so much.
And I would like to add that, of course, it's been a great pleasure to be with friends on screen and friends that I've been seeing in the chat. And it was just a delight. It's an honor to be on this program with Claudia. But I want to make one other comment, and that is that we haven't really lost that many participants from the beginning of this particular program. And so I thank everyone who was willing to stick through it with us. And I hope that Claudia and I will have opportunities to collaborate in the future, as I know that our organizations will. So thank you to the Chartered Institute and the ICC for organizing this.